Your attendance shows it. I want to thank our sponsors, of course, State Bar of Wisconsin. Thank you very much. We do a debate, Attorney General debate and Supreme Court debate with the State Bar every time there's an important race. So candidates, the winners who emerge will be invited, and I hope you'll nod your yes right now that you will be part of the State Bar debate. Yes, there you go. All right, I did my job, Larry. All right, I also want to thank our other sponsor, of course, the Wisconsin Institute for Law and Liberty. Thank you very much, Will, and all your guests for being part of this event. Okay, so this is not a debate, it's a forum. So I ask you to, please refrain from jeers or boos or wild applause or shouts of joy. Just try to keep it contained, okay? Please. Please silence your phones if you can. This is not being live streamed. It's being recorded for a full broadcast later today by Wisconsin Eye. And when we get the link, we'll post it at our site, and we'll also distribute it in our products. So you can go to wispolitics.com later on for that. So again, silence your phones. Thank you very much for attending. I'm now going to turn it over to the co-hosts of a Wisconsin Eye program that we are also part of called Rewind. J.R. Ross, he's the wispolitics.com editor, and Emily Fannin, she's the Capitol Bureau Chief for Channel 58 out of Milwaukee. So please welcome them and the candidates.
All right, so I will begin just talking to you guys about the format that we'll be doing today. Each candidate will have 90-second opening remarks, and each will make a statement in alphabetical order. We did draw names in the back on who will be going first for opening remarks. So with that, we have Everett Mitchell, who will be going first. Then we will be taking questions from myself and JR, and then we'll be gathering some questions from the audience to wrap up this 90-minute debate. All right, well, with that, we'll start with opening remarks. So Judge Everett Mitchell, you can begin.
Well, good afternoon, Wisconsin. Good afternoon, yes. My name is Everett Mitchell, and I'm running for Wisconsin Supreme Court because I believe our state deserves a justice that reflects the diversity and ideas and values of our entire state. For too long, partisanship has separated us so that we're not able to have the representation that Wisconsin people need. And as judge, since 2016, I've learned that justice is not just what you say, justice is what you do. And I believe that we need a justice that can represent what that means for our state. I've worked hard as a judge to be tough, but fair. I've worked hard to be proactive in our community rather than reactive, to address public safety as the needs of Dane County heads on. Like a couple of my opponents here, I've been a former prosecutor and now a judge, handing out punishment when necessary, but giving out hope when it's entirely needed as well. What separates me from my opponents is this. I've also worked with community leaders, faith leaders, school officials, LGBTQ leaders, police chiefs, sheriffs, and rank and file officers to take on crime, to stop it before it starts, and to prevent people from becoming victims in the first place. One of my proudest accomplishments is establishing the Juvenile Empowerment Team Committee, where we work with rank and file officers, school officials to go out and work with young people to ensure that they are not committing crimes in the first place. Because if they're not committing crimes, that means their futures are protected and there are new victims being harmed at the same time. My commitment to our young people is that here in Dane County, we want to make sure that crime is stopped. And I want to bring that vision and that passion throughout our entire state. I want people to know that you not only can trust the work that I have done, but also trust the vision that I have for what the rule of law and what our Supreme Court can be able to provide for our entire state. I look forward to this conversation and you getting to know a little bit more about me and me getting to be able to answer your questions about the things and the values of our state that will continue to be forward for the next 10 years. Thank you so very much.
Up next is going to be Janet Protasiewicz.
Thank you very much. Well, first I would like to thank WisPolitics for hosting this forum and thank all of you for turning out today to hear us talk about our views and what we think about some of the issues that may or may not come before the Wisconsin Supreme Court in such a critically important race. I got into this race to bring change and common sense back to our Supreme Court. I started thinking about it last spring. I could not sit back and watch extreme right-wing partisans hijack our Supreme Court. And that is why I got into this race, change and common sense. My entire life has been dedicated to community service. That is all I have ever wanted to do. For the past 30 years, I have worked as a prosecutor in Milwaukee County and as a judge in Milwaukee County. As a prosecutor, I handled some of the most violent, troubling cases that could ever come before a court and that affect a community in so very many ways. As a judge, I just came off of 3 years in homicide and sexual assault court. I have worked very, very hard to keep the community safe and make the tough calls necessary to ensure safety and uphold people's constitutional rights. I got into this race late last spring, and I can tell you I have been all over our beautiful state. And my God, our state is beautiful. It is gorgeous. I have been everywhere. During this period of time, I have garnered over 1,000 endorsements from judges, community leaders, and attorneys across our state. I have spent time listening to people and hearing about what they think is important. And I know what they think is important. What they want is the extremism to stop immediately. That is what people want. I am
Judge, your
here
time
to
is
tell
up.
you that
And
I am
judges,
that,
or if you could wrap up your final remarks.
that I
Thank you.
am that change, common sense candidate. Thank you.
Next up is Judge Jennifer Duro.
Well, thank you to WisPolitics for hosting this forum, to the moderators, and to the audience, both here and who will eventually watch online today, for taking time out of your busy schedule to be here. I'm Judge Jennifer Duro. I'm a wife, I'm a mother, I'm a coach, and I'm a judge. I'm a lifetime resident of Wisconsin. This is my home. Over my 26-year legal career, I have served as a prosecutor, a private practice attorney, and an advocate for abused and neglected children. And for the last 11 years, I have served as a Waukesha County judge, having won 2 elections as a trial court judge. I am running for the Supreme Court because the people of this great state of Wisconsin need and deserve a justice who will uphold the rule of law, protect our constitutional rights, and not inject their political bias by legislating from the bench. I have a depth and a breadth of experience unlike any other candidate, and an unwavering commitment to a fair and impartial judiciary. I am also the choice of law enforcement for the Wisconsin Supreme Court, having earned bipartisan support and more law enforcement endorsements than any other candidate on this stage. I also love this state and care deeply for its future. I want to do my part to ensure that my children, my children's children, and the families of Wisconsin have a safe and secure state in which to live, work, and play, and where judges and justices protect our constitutional rights.
Your time
I've
is up.
done
Please
that
just
as a
wrap
trial
up.
court judge, and now I'd be honored to do that on the Wisconsin Supreme Court.
Justice Dan Kelly, your opening remarks.
Thank you. Well, good afternoon, everyone. I'd like to take just a moment to introduce myself to you. I came to Wisconsin 40 years ago as a young man getting ready to study at Carroll College. I fell in love with the people of Wisconsin the very first day I was here because of the very first people that I met. They were the most warm and welcoming people that you could imagine. And over a long weekend of camping and fishing, they taught me what it is to be a Wisconsinite. And I learned from them the Wisconsinites are the people of the open hand and the generous hearts. A few years later, I met my wife at an InterVarsity Christian Fellowship meeting at school, and 33 years and 5 children later, they're my treasures. And the people of Wisconsin are the same as when I met them 40 years ago. The people of the open hand and the generous heart. That's one of the reasons it has been such an honor and a privilege to serve you as one of your Supreme Court justices. And this afternoon, I'm looking forward to continuing a conversation that I started many years ago about the proper role and function of our Supreme Court and how critical it is to elect a justice whose commitment is to understanding and applying the original public meaning of our Constitution, preserving the rule of law, and preventing politics from interfering with the work of the court. Thank you so much.
Now, much like we drew who would speak first, opening comments, we're going to rotate who answers each question first to keep it fair. Judge Protasiewicz, you get the first question here. This race is for ideological control of the Supreme Court. We know judges often hate labels. So the public views Judges Mitchell and Protasiewicz as left of center. They view Judge Dorow and Justice Kelly as right of center. Outside groups are poised to spend millions of dollars on this race because of what is perceived to be at stake, and they expect the candidate they support will vote the quote-unquote right way. Can you point to any ruling you've issued or personal experience with the law that shows you'll be an independent thinker on the court rather than a reliable vote for one side or the other?
Thank you. Judicial independence is absolutely crucial and critical. Wisconsinites deserve a court that is independent. Wisconsinites deserve a court where there's not a thumb on the scale. Wisconsinites deserve a court where outcomes are not preordained. So the question is, what have I done to show you that I'm a judicial independent? Plenty. I am in court every single day. I told you I just came off of 3 years in homicide and sexual assault court. Before that, I spent 2 years in a high-intensity drug trafficking court. Before that, a year in domestic violence court. Every single day, I heard arguments from district attorneys, from defense attorneys, and I've heard victims tell me what's important to them. How do you know I'm independent? Even though I'm a career prosecutor, I side with the person or party who I think is most appropriate. Sometimes I do what the state wants, sometimes I do what the defense wants, but you never know. I follow the law, I uphold the Constitution, and that's what I plan to do, and that's what I plan to continue to do if you elect me as your next justice of the Wisconsin Supreme Court. Wisconsinites deserve better than what we have had. We deserve much better, and that is what I plan to do. Fair and independent all the time.
Judge Dorow, you're next with that question.
Thank you. The core of my judicial approach has always been fairness and impartiality. The people who appear before a judge expect and deserve this. I say they should demand this. For the past 11 years, I have administered justice fairly, faithfully, and impartially. Sometimes judges are faced with difficult litigants. I recently had such an experience in a case that I handled. The citizens of Wisconsin got a very unique opportunity to see my approach to fairness and justice. And I was deeply touched by the feedback that I got from around the world for how I handled that case. I heard from judges across the country and even inmates who sent letters praising my efforts to be fair and impartial in the face of extreme disrespect, disruption, and at times even vile behavior. Through it all, I protected the very rights of the person who engaged in this behavior while also ensuring that the rights of the victims and the witnesses were also protected. You can expect nothing less from me as your next Supreme Court Justice. Fairness, impartiality, that is what I will be.
Justice Kelly.
Thank you. I think it's important to emphasize the significance of the premise to that question. Politics is poison to the work of the court. Now, everybody who comes to the court, regardless of what they might tell you, everybody has political beliefs. The question is whether you can set them aside to do the work of the court. In order to do that, you need to have a methodology developed and ready at hand that you can apply consistently every single day, making sure that the results of the decision are commanded by the law and are not influenced by one's personal beliefs or personal politics. The methodology I use is really quite straightforward. I start always with the premises, the law that applies to the case. And then I exercise rigorous logic to move from those premises all the way down to the conclusion. And when you're done, you should be able to look back and see an unbroken chain of logic connecting the premises to the conclusion. And if you see an unbroken chain, that's your guarantee that the conclusion is commanded by the law rather than by the individual's personal preferences or personal politics. Now, I've been told that there are some of the opinions that I've written on the court that have not been the favorite of those who might be considered otherwise to be my supporters. Because in truth, every opinion that I've written for the Supreme Court, every dissent, every concurrence has been based 100% on what the law is, not on what I think it ought to be, and certainly not on what any political party or member of the legislature thinks that it ought to be. My commitment has always been the same, simply applying the law and using rigorous logic to reach the conclusion so that the people of Wisconsin can have confidence that the decisions of the courts are solely informed by the law. And I've written my opinions in such a way that they are accessible to anyone, regardless of whether they have a legal background, because I understand that I'm using borrowed authority from the people of Wisconsin. And every opinion that I write is my report to the people of Wisconsin on what I have done with their borrowed authority. And so I've made it accessible, I've made it logical, so that anyone in this state can confirm that the opinions that I write are commanded solely by the law.
Judge Mitchell.
I would say that shortly after I took the bench, one of the first things I realized is how unfair the system truly is. There's so many inequalities within our system that if you don't have the income to be able to have representation in the court system, your voice isn't heard. Fairness for me meant to make sure that my courtroom was a place where every voice had an opportunity to be heard, regardless of the income that you did or did not have, regardless of your race, regardless of your self-identified gender. And it was to give a space so that people could be heard regardless of those things. And when you're a judge who oversees juvenile cases, it becomes even more important because you're not dealing with adults, you're dealing with children who often have no voice. Children don't have a lobbyist group who can come in and lobby for how you treat them. So it's up to the judge who hears those cases to make sure that they're creating an environment that is both fair, that is honest, and most importantly, transparent in those cases. I do believe that there are times when politics can try its best to enter into that space, but a judge who is committed to the rule of law and committed to fairness in our state will make sure that they understand that when a person comes in, you don't ask them, are you Republican, are you Democrat, are you Green Party, are you independent? They're Wisconsinites, and they deserve to have their cases heard without any bias whatsoever. And I always say any judge who comes to the bench with a predetermined idea already should recuse him or herself from the process, because the fairness of our system is at stake. The integrity of the court system is at stake. And so we have to suspend those things. So at that moment in which somebody needs to be heard, that we remain curious to the facts that are being brought before us. And when you lose that curiosity, you're no longer a judge. You're a partisan tool that somebody can use to be able to get what they want. And I can promise you, I have a whole lot in my resume that shows you I'm nobody's tool. I stand on the beliefs, I stand on what's right, I stand on what's fair, and I live in that moment and I believe what it is. I remember as a pastor when I was compelled to marry a same-sex couple in my congregation, and people told me, they said, we don't do that. Black Baptist preachers don't do that. And I said to them, we're going to stand on what is right, even before the Supreme Court gave us cover to do so. And I married those two women in my congregation because they had been together 42 years. And when they asked me would I do it, I said, of course I will. I don't know many straight people that's been together 42 years. And so I married that same-sex couple, and I pastored the only open and affirming congregation. Why? Because I'm independent, and I cannot be controlled by others, groups, or influences. So the example that you said, give us an example. I remember when I had a case before me with a lawyer that I loved to death came into my courtroom, and he presented something before me, and I remember that it was against Scott Walker. And I looked at the law, looked at the facts, and everything in me said this is about the rule of law, not about my friend. That's not my friend in this moment. He's a litigant, and I got to make sure I follow the rule of law. And so I made that decision to uphold the decision related to the Scott Walker administration, because for me, that is the job. Now afterwards, we can go get some beers, and he was mad at me for 2.5 years, but I had to do the job that I was called, that I was committed to doing, and that's what I did in that moment. So thank you.
All right, continuing in our order, Judge Durrell, we will start with you with this question. The state Supreme Court has rejected past petitions asking the justices to set a recusal standard for cases in which a party has contributed to their campaign. Essentially, the court has said it is up to each judge to make a decision on whether they can be impartial. Still, the state Democratic and Republican parties are already fundraising for the race and are expected to spend millions of dollars in this campaign. 1, do you believe the court was correct in rejecting requests to set a standard for recusal? And 2, will you hear cases involving the state political parties, knowing they will and likely spend against you in this race?
Well, first and foremost, my integrity cannot be bought by anyone. We have rules and statutes already that address recusal, and they are important. I would, of course, follow them and apply them to the facts of any given case. At the same time, I know that recusal is often used as a weapon by litigants to secure the judges they prefer, and that is wrong. Justice requires that judges and justices hear the cases that come before the court. We have an ethical obligation to diligently take care of our cases. That is the job that the people of Wisconsin and of our counties elect us to do. I often think of recusal in the context of a one-judge county. A judge in a one-judge county knows probably everyone, or at least a large portion of that county's population. And if we start looking at money, why don't we look at time? Or why don't we look at the efforts that other people put even into our campaigns? But if a judge in a one-judge county would recuse itself based on every relationship that that judge had, even if it's just a litigant or an attorney or even a financial donation, without more, that judge wouldn't handle the cases that that judge was elected to do. We can still look at the cases from a broader perspective, even when they come to the Supreme Court. And again, go back to the rules, go back to the law, because the law is important, and our statutes and our Supreme Court rules on recusal and the case law that talks about them are very important, and I would start with that, and I would then apply those laws and those principles to the facts of the case before me.
Thank you. Justice Kelly, you are next.
Here's where I start. I understand that all of the authority to create and maintain governments in the state of Wisconsin comes from, well, you, we the people of Wisconsin. And it comes to us only as a loan. And that loan is mediated by the Constitution that the people of Wisconsin have decided to create and maintain. And the point of this is that the question of recusal is for the people of Wisconsin to decide if they believe that there should be new rules or different rules governing how that is handled. Right now, what they've decided is that there is a cap on contributions to judicial candidates. That's their call. They believe that to be an appropriate way of handling that issue. The people of Wisconsin decided that our judiciary is to be an elected judiciary. There are many different ways of doing that. You could have an appointive judiciary. You could have a Senate confirmation for judicial nominees. But Wisconsin has decided on elections. And they know well enough that elections require that the candidates have the ability to get their messages out to the people of Wisconsin. And so they've put their stamp of approval on the contributions they think is appropriate for a judicial candidate to receive and continue to sit on cases. Now, I think on top of that is the individual responsibility of the Supreme Court justice. Only we can truly know whether we are going to be adversely impacted by someone's contribution, by someone's time or efforts in supporting us, or conversely, by someone who is spent against us in a campaign. The truth of the matter is, it would be extraordinarily difficult to develop a standard of recusal that could capture all of those elements and all of those dynamics in a way that could be administered in an intelligent fashion. The real key to recusal is this. It's the choice of the people of Wisconsin and who they send to their Supreme Court. And that has to begin with a level of trust in who you send. It has to be a commitment to looking at the character of the person and understanding that that person will stay true to the law and will not allow other factors to influence the way they decide cases. And that if they should encounter a circumstance in which there is an outside factor that is so powerful, so dynamic, that would threaten to change the result of a case, that that person would have the integrity and the honor to step aside. And that's what recusal is about.
Up next is Judge Everett Mitchell.
So if you ever go to the Wisconsin Supreme Court website, there's a seal. It's a beautiful seal because it's different than the other seals that I've seen representing justice. The Wisconsin Supreme Court seal has a hand that's holding the scale. And that hand that's holding the scale is meant to say that there's a certain balance that judges and justices are supposed to have when it comes to thinking about what justice should look like in every case. So when I think about recusal, I think about that symbol, that when a judge's hand starts to tilt the balance in a different direction, he or she needs to make sure that they recuse themselves. I think that is the ultimate decision that we all make. I get that question all the time as a person who's always in the community. The first thing people always ask for, judge, will you have to recuse yourself because you know so many people? I say, no. Just because I'm popular doesn't mean I got to recuse myself from every case. What it means is that I have to make sure that there is a standard in which I review and I explain the relationships up front. I think what has often made the court seem as though it's a dark place is because justices and judges are not always honest about the relationships that they have when they see them in the courtroom. So anytime I see somebody that comes up, I make sure every party is aware of what their relationships may look like. And I make sure that every party is aware that those things are important and they may be in play so that everybody understands the rules of engagement in that moment that we're going to address the particular case. Because my view has always been we should never be in the point where we're tipping the balance of power in one direction or the other because of the relationships that we have. As I said earlier, it is about curiosity. And I think that there are rules related to recusal. And if you are in a position where you do believe that you can no longer effectively, fairly, impartially administer a decision, or you will be able to make rulings in a particular case even before it goes before a jury, or if you have it to answer yourself in a court trial. If you cannot listen to evidence in a fair manner, then you need to make sure that you give the person in front of you the due respect to tell them, I need to get off this particular case. And that goes back to the integrity of the individuals that you elect to be in these positions. That goes back to people understanding that it's not about having a particular victory. It is about that persons or the bodies or the issues that are in front of you, make sure that they get litigated fairly in a way that brings and holds the integrity of our court system in place at the same time. So again, I go back to the example. I think you need a justice who has an even hand. And they make sure that they don't tilt it, but they let the facts tilt it in the direction that it's supposed to go. So thank you.
Judge Protasiewicz, up next.
I think we need a recusal rule. I think we have two distinct scenarios that we've been talking about. Sure, we all go into our courtrooms and we all know many of the people on our cases. We always disclose. I know the plaintiff, I know the respondent, I know the defendant. You know, I know the defendant's attorney is one of my court commissioners. We always disclose that. But I take it a step further when it comes to the political contributions. I think that due to the extreme partisanship and the amount of money that comes into races like this, we absolutely need a recusal rule. Now, what should that recusal rule be? I think the public should be able to weigh in on that. I know that it has been talked about and presented to the Supreme Court in the past, and the idea of talking about the recusal rule has been rejected. But I think there should be open hearings about that. I don't think I'm in the minority. I can tell you that there are a majority of retired Wisconsin Circuit Court judges who also think there should be a recusal rule. And I also understand that there are limits as to how much money an individual or a union can contribute to a personal campaign. And in this particular campaign, an individual can contribute $20,000 to my campaign. The question is, if you're on the Supreme Court, does $20,000 sway you or not? Each individual would have their own answer to that. However, that's not what we're talking about. We're talking about outside money that's going to come into this campaign in millions and millions of dollars. Millions of dollars. That is why there has to be a recusal rule. The public has to weigh in. I'm not going to sit here and tell you what I think an exact number is, but I absolutely think there has to be a hearing. The public has to weigh in, and I think there should be a recusal rule, 100%. Thank you.
Judge Doro, you have that question?
I answered the question.
Okay,
already.
thank you.
Thank you.
Yeah, I'm like,
All right, just making sure we're on the same page. All right.
in the
Justice
same order. We're good.
Justice Kelly, you're up next. Now, Judge Doro and Justice Kelly, the applications you filled out for an appointment to the bench asked you for the worst ruling by the Wisconsin Supreme Court in the last 30 years. Judge Doro, in 2011, you cited a 2003 U.S. Supreme Court ruling overturning a Texas anti-sodomy law. Justice Kelly, you cited a 2005 ruling from that court that said that justified the government taking private property to be put to a more productive economic use. For the two of you, I want to know, is that still the worst decision you've seen in the last 3 decades? For Judges Mitchell and Protasiewicz, what's the worst ruling you've seen the last 3 decades in Wisconsin or U.S. Supreme Courts? So Justice Kelly up first.
I think that stands up well. You know, we look at our Wisconsin Constitution, and the very first article and the very first section says that we are endowed with inalienable rights, that amongst these are life and liberty and the pursuit of happiness. And the governments are created to protect those rights, gaining their just powers from the consent of the governed. When the government steps in and takes private property, it's not just an economic problem for the person who loses the property. It's also a question of liberty. You've acquired that property, whether it's real estate or personal property, for a reason, because you believe that it would be productive, that it would be enjoyable, because it would advance your pursuit of happiness. And when the government steps in and takes that from you, it has to have a really good reason. And there has to be just compensation. But the just compensation only takes care of the financial aspect of that intrusion. So I think any opinion of a court that would allow for the government to, without regard to absolute necessity of taking it for the purpose of public use, that would allow a government to take that property is inappropriate. See, the problem in that case was it was not being taken for public use, private use, transferring it from one private party to another. And this is a significant interference with the liberties that our Constitution protects. And so I think that opinion stands up well as one of the worst opinions.
Thank you. Judge Mitchell?
So I think for me, there are a lot of Supreme Court decisions in various categories that have had very adverse impacts. I think I can think of no other greater impact that I have seen with the overturning of the Roe decision. I think the overturning of the Roe decision really put at jeopardy the idea of privacy that we were founded in the 14th Amendment as a critical place of infrastructure of how we understood the law. it was one of the first times that I can remember in my own history that a right was reached into the lives of people and taken away. While we also understand that, the decision really focused a lot on, precedent, it also invalidated the ways in which courts often use precedents to make sure that we're ensuring the rights of individuals are consistently and maintained and protected at the same time. The invalidation of a protection for reproductive choice also was telegraphed through Justice Thomas to also look at, not only same gender relationships, but also, all of the other constitutional rights that we also seen as protected as well. So I think overturning that also put our country in a very, chaotic place where you may have 50 different types of interpretations about reproductive choice, and our states are struggling to try to figure out where these things mean, because that was taken away from something that the majority of individuals in our communities in our states had also thought was foundational at that time. So there are a lot of consequential decisions, whether we're talking about Shelby County versus Holder that talked about voting rights, or Graham versus Connor that talked about the engagement around police reform. But this one is significant because it was the first time in my study of the law that I can see that the Supreme Court went and took a right for which there had been a right for people for over 50 years. And we're dealing with the consequences of that instability all throughout our country and all throughout many people's lives right now. So I'll leave it with that.
Thank you. Judge Protasiewicz.
I agree. I think the Dobbs decision is the worst Supreme Court decision that comes to mind. That is the epitome and definition of judicial activism. Quite frankly, I was surprised when they reached and rendered that decision. 3 generations of women have counted on Roe v. Wade to allow them to make their own decisions in regard to reproductive rights. Now, I can't tell you where I'll end up on any case. I can tell you a little bit about my values, and I assume I'd be asked about that because it was secret, what my values are in regard to Roe v. Wade and in regard to the Dobbs case. Privacy issue is paramount. My value is that women should be able to make their reproductive right decisions themselves. Sure, go ahead, talk to your clergy, talk to your family, talk to your healthcare provider. But in the end, my values tell me that that should be your decision. That is exactly why we need to bring common sense back to the court. That's exactly why we need to bring change back to the court, to not only uphold our Constitution, to not only employ stare decisis, but to uphold the will of the people who have relied on, I think, 3 generations, would that be 50 years potentially? 3 generations of women. Many women never knew a world before Roe. Now they certainly do. So to me, that is the most critically poor decision, and as I indicated earlier, an absolute example of judicial activism.
Thank you. Judge Dorough.
Thank you. I'll be honest with all of you. Sometimes I don't personally agree with the law that I'm applying, and I'm sure that's also true for the U.S. and Wisconsin Supreme Court justices. Sometimes the words or even the statutes themselves are stupid. But stupid doesn't mean unconstitutional. It doesn't matter to my job whether I like the words or even to agree with the law. My job is to apply the words and what they mean. If I were running for the Senate or Assembly, I might campaign on changing some laws. But I'm not running for the legislature. None of us are. I'm running for a seat on the Wisconsin Supreme Court. Politics have absolutely no place in the courtroom, and we should not be legislators in robes. Thank you.
All right, this next question will start with Judge Mitchell. We now want to flip that question that we just asked you around. What ruling has most shaped your judicial philosophy?
And if you have a judicial philosophy, it is rooted in probably a judicial mentor that you've used to better understand how the law understands. Probably my judicial is Justice Thurgood Marshall. And I think his argument in the Brown versus Board of Education, when it overturned the separate but equal doctrine, was one of those decisions when you're growing up as a young man learning about what the law is, that you understand how the law can be used to oppress and demean and hurt communities of color because of the fact that they're using the law as a foundation for that erosion. And so the fact that, Justice Marshall was educated by Charles Hamilton Houston at Howard University, and he was educated on the idea that the 14th Amendment could be the vehicle that is used to change the dynamics of how we understood the law, and that you can use the law as a force for good, that you can use the law as a force for change and making people's lives better. No, we're not up here trying to be legislators, but even the language of the law that we're supposed to enforce itself should make sure that lives are being better if we have the discretion to do so. And it was Justice Marshall's ways in which he thought about the law and using the law that gave me a sense of purpose to my own judicial philosophy, so that when I think about the discretion that judges have, and trust me, Wisconsin, judges, especially those who served in the district courts, we have a lot of discretion where we can implement all kinds of things that are not codified in statute nor in case law that you have to make ruling on every day. So you make those decisions. And so I still remember the time that I have these ideas about Justice Marshall using it and Brown versus Board of Education and the decision to desegregate all these schools to bring our communities together. I think about the times in my courtroom, like when I had the young child come into my courtroom, blonde, blue-eyed child, in handcuffs, belts, and restraints. And I asked myself, what do I use my discretion for in this moment to make this child better, to make sure that the lives of these children are better? And when I pushed toward taking away handcuffs off of children, not only in Dane County, but also joining the petition that we get before the Supreme Court to do it statewide, it was a reminder that the law not only is about what's in books and statutes and case law, but the law is what it looks like in the lives of people who have the impact to change something that is wrong before you. And that is what a judge is supposed to do also. Not only just follow patterns and trends of what everybody else is, but ask the critical question of why are we doing this and can we change it? And so always paying attention to how passionately Justice Marshall argued for integration in a world that seemed to be set in how we do things gave me the courage to do some of the stuff that I have done to make the judiciary reflect a certain value system of fairness, kindness, and equality.
Judge Bertazewicz.
Judicial philosophy is, I'm not going to say it's complicated. It is what you do every single day that you walk into your courtroom. And my goal in my judicial philosophy is that every single person who walks into my courtroom gets a fair shake. I'm a common sense judge. I was a common sense prosecutor, and I'll be a common sense justice on your Supreme Court. There's no thumb on the scale putting down a weight toward one side or the other. Everybody is treated absolutely fairly. I've rendered some sentences that parties don't like, but my goal is, when they walk out of the courtroom, that everybody feels as though they've been treated fairly. In regard to specific cases, I have a couple of them that have really impacted me. We've talked about Brown versus the School of Education. We talked a little bit about Plessy versus Ferguson. It's precursor. And I think it's critical that when you look at those two cases, you see that Plessy versus Ferguson talked about separate but equal. What did we learn back in high school? Always separate, never equal. That's what we learned in Plessy v. Ferguson. Then we come forward to the Board of Education, where those laws were struck down. And to me, in my judicial philosophy, what it tells you is that we are a living, breathing document. And our laws change and they evolve, and the case law changes and evolves. I think that that is critically important. So fairness, evolution, no thumb on the scale, everybody being treated equitably would be what I would have to say is my judicial philosophy.
Judge Durrell.
So the role of a judge, at its core, is to apply the law, not make it. Laws are written, and words have meaning. Everybody knows this. We use words every single day in the contracts we enter into, in the wills we make, so that they will be applied upon our death. We expect that the words we use in those moments of our wills and our contracts won't be twisted later on by giving them a meaning that we didn't intend or, frankly, wasn't even in existence when we used them. Statutes and the Constitution should be treated no differently. The role of a judge should not be interfered with by our political views. We wear a black robe in part to tell of our authority, but also to shield us from the biases and the prejudice that we undoubtedly bring from our personal experiences. You know, I've spent 9 of my 11 years on the trial court bench in key leadership positions, dedicating my career to improving the justice system. I have been appointed 3 times by the Wisconsin Supreme Court to serve as a chief judge. And I've been selected and have the honor and privilege by my peers to serve as the chair of the Committee of Chief Judges, or Chief of the Chiefs as we affectionately refer to it. That is where judges can really have an impact on improving the justice system. Of course, we need to be fair and impartial in every case that comes before us. The litigants deserve it. The victims deserve it. The families of everyone involved, the accused, they deserve it as well. But it starts and ends with our commitment to be fair and impartial and give due respect to the role that our founders gave to us when they instituted the 3 branches of government. Thank you.
Justice Kelly?
I'm influenced by all of the court opinions in which the justices have demonstrated fidelity to the Constitution. That's the North Star for us, fidelity to the Constitution. Now, sometimes circumstances call for the Constitution to change. That's why both the United States Constitution and our Wisconsin Constitution provide for amendments in which the people and their representatives decide how and when those constitutions are going to change. It does not change in the hands of the court. It must not ever change in the hands of the court. That is a fundamentally illegitimate step to take. And the reason for that is because of the nature of the authority that we wield. You see, when the people of Wisconsin put together our Constitution, they did not ask us what our views on the Constitution were. They did not ask us to decide what laws are good and effective and which are not. They asked us to do one thing. Please decide our cases according to the way the law is written. And we the people, will take care of it if those laws or the Constitution needs to change. Now, there's been mention both of Plessy and Brown versus Board of Education, and I think that's a great example. Plessy was wrong. It was wrong the day it was decided. It was wrong every day after that. And when Brown came along and overruled it, it was not because they took the Constitution into their own hands to change it. It is because they looked at Plessy and they compared it to the Constitution, and they said Plessy was simply wrong. And we are fixing that error. Now, I'm the only candidate in this race who has experience doing that sort of thing. Now, this might be a little self-referential, I apologize for that, but I wrote the opinion in Tetra Tech versus Department of Revenue. Now, that wasn't a case as monumental as Plessy and Brown, but it was a question of whether the Supreme Court of the state of Wisconsin had gone off on the wrong track for about 100 years. And the question there was who decides, as a final matter, how to apply the law. Is it an executive agency, or is it the Supreme Court, the branch that the people of Wisconsin have entrusted with the judicial power? And over a course of about 100 years, the Supreme Court had slowly begun deferring to administrative agencies' interpretation of the law. And they concluded that we have to defer to what they think the law is. So we researched that, we compared it to the Constitution, and we concluded that those precedents were wrong. They were wrong the day they were decided. They were wrong every day after that. And so it was our responsibility and our job to correct that wrong. And it was my honor to write the opinion in Tetra Tech, in which we said, we are repatriating the authority of the court where it belongs, with the judiciary. And the consequence of that is that when you have cases in which the government is a party, you will be assured that it's the court applying the law and not your opponent in the courtroom.
Thank you. Emily will tell you from our preparation for rewind that I'm a redistricting dork, total, complete, and absolute dork. So I want to apologize to our two justices here for summarizing the dozens and dozens and dozens of pages you guys wrote about redistricting the past year and a half. That said, Judge Protasiewicz, the court issued several rulings in that case. One was the parties had to take a least change approach to the maps they submitted. They then eventually picked a map drawn by GOP lawmakers because it followed that directive and was race neutral. My question is, was the court correct to require a least change approach? And do you believe there are conditions in Wisconsin that meet the requirements to allow race to be considered as a factor in drawing political boundaries?
So let's be clear here. The maps are rigged, bottom line. Absolutely, positively rigged. They do not reflect the people in this state. They do not reflect accurately representation, neither the state assembly or the state senate. They are rigged, period. I'm coming right out and saying that. I don't think you could sell to any reasonable person that the maps are fair. Least change approach, I think the idea of it might sound good to some people. I see no basis for it in the Constitution, no basis in case law. Basically, what the least change approach has done has taken votes away from, or meaningful votes away, from people in larger communities in Dane County and in Milwaukee County. I believe the gerrymandering decision was wrong. As I indicated to you before, I can't ever tell you what I'm going to do on a particular case, but I can tell you my values and common sense tell you that it's wrong. And I was talking to somebody, and the person used this phrase with me in regard to the maps. And I wrote it down so I get it right, because I think it is so interesting. They said, in the state of Wisconsin, do the voters choose the politicians, or do the politicians choose the voters, right? And that absolutely resonates with me. So as I've indicated, I think those maps are rigged. I think they're unfair. I don't think they fairly reflect the population in our state. Thank you.
Judge Doro.
I think we all would agree that what happened this past year was very interesting and unique. Following the census every 10 years, the legislature and the governor are tasked with coming up with new maps. The process is guided by the principle of one person, one vote, the Voting Rights Act, and the Wisconsin Constitution. When the legislature and the governor could not agree on the new maps, the Supreme Court was asked to step in. And then, of course, we saw the very unusual back and forth between the Wisconsin Supreme Court and the United States Supreme Court. Ultimately, after the U.S. Supreme Court reversed our court, the 2020 map proposed by the legislature was adopted. Now, there is talk about further challenges, so I will not put myself in a position to prejudge anything. But as with any case, I will listen to the challenge and I will apply the law to the facts at hand. Thank you.
Justice Kelly.
I think when someone tells you what their values are in answer to a legal question, they're telling you how they're going to decide a case. A redistricting map is an entirely political act. It involves political calculation. It involves communities of interest. It involves give and take. It involves compromise. It involves the political process. It is political from start to end. Now, there are legal elements to a map. The phrase least change is meant to capture what the court's responsibility is when it has to consider a redistricting map. See, we do have legal standards for what a map must do. It has to have equal population. And if you look at our Constitution, Article 4, Section 4, it tells us that the districts must be compact and contiguous. These are legal requirements. And courts are for the law, and the law alone. It is not for politics. And so when a map comes to the court with a challenge that it is unlawful in some regard, the court's responsibility is limited to considering the legal challenges, not the political challenges. How districts get apportioned according to political considerations must have no purchase in the courts, unless we are dead set on tearing down the distinctions between the branches of government that our Constitution creates. But if we are going to preserve the constitutional order, if we are going to make sure that our courts exist wholly and only for the purpose of deciding legal questions, then we can't let our values, our personal values, or our personal politics reorient what the different branches of government are supposed to do. When that map comes to the court, its mandate is the same as with respect to every other case that has ever come before the court or will ever come before the court. Decide questions of law, not politics.
Thank you. Judge Mitchell?
I think I'll start my comments around this idea from Justice Ginsburg in her dissent in Shelby County versus Alabama versus Holden. And Justice Ginsburg said the evolution of voting discrimination into more subtle second-generation barriers is powerful evidence that a remedy as effective as preclearance remains vital to protect minority voting rights and to prevent backsliding. She said the second-generation barriers are no longer subtle. It's a reminder that when we think about the nature of maps and the decision that the Supreme Court was, in many ways, had to make that decision, it is because our democracy in many ways has become broken. The partisanship has become broken, and now they're looking to courts to answer questions for which courts should be focused on the law, but now we're being forced to answer questions because democracy is no longer working. So I think in order to restore people's faith in our democracy, what we need to do is to ensure that legislative districts are drawn in a fair, nonpartisan way. And I think the way how extremely partisan our maps have gotten, we're saying to folks, both on the left and to the right, that your voices don't matter in these districts. Only party leadership does. So I think you're right, in the sense that, yes, the law is a place for us to consider these bigger things, but it's also the implications that our laws will have upon the lives of people that I believe our Constitution asks for us to be able to make. Just an example that we were given earlier when we talked about overturning Plessy and implementing Brown versus Board of Education. They implemented that idea not because they were following the law, because they understood the implications of having children educated in separate environments and what that meant. It's also the understanding of why the Supreme Court also supported same-gender marriage, because of the social implications for what this also looked like as relates to privacy. So I believe our maps that we have now have rid so many people of a particular voice that is necessary, and the standard of least change approach. Anytime Anytime as an African American in judicial spaces hear the word least change approach, it just brings up all kind of past trauma of how people did want to change stuff because it did not empower our communities. And our communities, whether it is black or it is native, I bet you if you had some native jurists here, the same thing, our indigenous community would say the same thing. The least change approach always means the same. It always means wait. It always means never. And it always means more oppression and more pain for folks who don't have voice in the political process. So the role in which we were to play, we all have values, and it is important to you to know our values so you can decide who you want to be sitting in that black robe making decisions about the values of our state. I'm going to say this and I'm done. I wasn't born in Wisconsin, but I chose Wisconsin as a place to have my children, as a place to build community because of the values of the people that I see in this state. All throughout this state, I've traveled, my wife and I traveled this entire state with the intended purpose of introducing the state to a judge named Everett Mitchell. And everybody in my community was like, you got to be careful when you go throughout the state. And I said to them, when I gave a 5-minute speech and the person asked me, you want to come hang out with us later? I was like, okay, this is Wisconsin because it is more welcoming. And those are the people that I make sure that we pay attention to in that space because they are the ones who we are making a constitutional commitment to ensure that we're following the rule of law a particular kind of way. Thank you.
All right, we'll do one more question for all of you and then take some audience questions. Judge Durrell, we'll start with you on this one. The U.S. Supreme Court ruled in 2008 that the right to bear arms doesn't only apply to militia, but to all individuals. In doing so, it overturned the District of Columbia's handgun ban and requirement that lawfully owned rifles and shotguns be kept unloaded, disassembled, or bound by a trigger lock. Would you have sided with the majority or minority in that case? And please explain why.
That was a lot. Hold on, can you read that question one more time?
Yeah.
That was like 19 statements in one. Say it one.
Thank you.
I will
What the
repeat it
law
one more
was,
time.
what you do, okay, go ahead.
The U.S. Supreme Court ruled in 2008 that the right to bear arms doesn't only apply to militia, but to all individuals. In doing so, it overturned the District of Columbia's handgun ban and requirement that lawfully owned rifles and shotguns be kept unloaded, disassembled, or bound by a trigger lock. The question is, would you have sided with the majority or minority in that case? And please explain why. Judge Durrell.
In our country, we have not only the Constitution that's made up of the original words of our founders, but then we have the Bill of Rights. And within that Bill of Rights, there are a number of very important rights that are important to our communities, are important to our democracy. And I believe we shouldn't pick and choose which ones we need to follow. As with any case before me, I'm going to start with the law. I'm going to look at what the law means. I'm going to consider the challenge that is before me, the facts of that case, and then apply the law as written to the facts of that case. That's really at the core of what a judge and justice is. I think we all can imagine a variety of settings where the Second Amendment is brought to the Supreme Court for a decision, or that is implicated in a case. I want to be true to my ethical obligations about not prejudging or letting my personal biases or opinions, or even what I want the law to be or not be, influence what I do. And that means I need to start again, as I've said before, with the facts, with the law, and only render a decision that addresses those very specific things. So because cases raising the Second Amendment are very likely to come before the Supreme Court, I'm going to leave my answer at that and make a pledge to all of you that once again, I will start with the law and I will apply that law to the facts. Every decision, every time.
Thank you. Justice Kelly?
So I've heard the Second Amendment is something of a controversial provision of our Bill of Rights. You know, one of the reasons that we create constitutional language is to put it beyond the reach of simple majority rule, right? It might be that at any given time in our history, the people would favor the keeping and bearing of arms. And then time goes along, circumstances change, and people might decide, well, I don't like that so much anymore. Well, we have a way of accommodating those changes in time. We call it amendments. The Second Amendment came into existence, as its name states, as an amendment. Did not exist in the original Constitution. So the question is, when we see that language that promises the right to keep and bear arms, what do we do with it? Do we take a survey of current impressions and preferences and determine, do most people like the terms of the Second Amendment? And if they do, then we will uphold the terms and we will say that it is okay to keep and bear arms. Or do we say, you know, times have changed and people really aren't that committed to the keeping and bearing of arms anymore, and so as justices, we're going to strike that down. The role of the court is to not look at passing fads and fancies, changes in political opinion, is to apply the law. Now, in this instance, the question is, what did that language mean when it was passed and adopted in 1791? So the role of the court is to discover the original public meaning of the terms included in the Second Amendment, and then to faithfully apply those without regard to what opinion polls might say today about the popularity or lack thereof of the Second Amendment. And that's the role of a justice. And I can tell you, it's not easy. There are rulings that I've made that were commanded by our law, by our Constitution. And I was raked over the coals, sometimes by the left, sometimes by the right. But my commitment every single time was to simply applying the law as it exists, because my confidence is in the people of Wisconsin, that if they are so opposed to a particular standard, if they are so desirous of change in the law, they will move heaven and earth to make sure that it changes. And they've done that a lot. You can look at our Constitution and go through and see all the amendments that have occurred over time. So my confidence is in the people of Wisconsin, not in 4 lawyers sitting in a Madison courtroom, thinking that they know what the Constitution ought to say, thinking they know what the law ought to be. Our responsibility is to set that aside and wait for the people of Wisconsin to make their call. Do I think the Heller decision was right? Of course it was. It inquired into the original public meaning of the Second Amendment, and that's precisely what it meant, the right to keep and bear arms. Do I understand that there are people who wish that that were not true? Yes, I do. And to those of you, I suggest you do your organizing and you follow the constitutional process for changing that, rather than asking your members of the court to disregard their oath of office, to steal the power of the people of Wisconsin or the legislature to change it themselves.
Thank you. Judge Mitchell?
I'll start by answering your question up front. Is that since I didn't actually, hear the facts of that case, I'm not going to tell you how I would rule in that case. Does that make sense? No? All right. But in terms of values, what I think is very important is, I think Dan said something when he talked about, well, one group that disagrees is that we should really be paying attention to our law enforcement officers, our rank and file, who also indicated that the number of guns on the streets outnumber the amount of Americans that we have. Everybody in America, if we look at all the guns on the street, everybody could have 7 guns on them. And I think listening to groups of people, one are law enforcement, who have been saying about the number of guns on the streets makes their job almost unsafe. I think about the tragic case of the young man, 10 years old, in Milwaukee, took his mother's life. It is a reminder that guns are not toys. How we play with guns are not toys. How we talk about these guns and these mass violent tools that are being used to take lives of so many people is a consistent reminder of us that the decisions that we make and how we make them, how we understand the rule of law and what that looks like has real implications on people's lives. Now, I'm a carry and conceal owner, and so I have my permit, and so I recognize the importance of Second Amendment, and I recognize and I own that, because that is an important value that I think everybody should have. But the stuff that we're seeing right now has far-reaching implications of people whose lives are being taken on an everyday basis. Murder rates all the way in Milwaukee and different states around us remind us of the critical nature in which we are supposed to be engaging in these conversations. We may not understand how we were ruled because of the fact that, we're supposed to follow the rule of law, but it's clear that when certain facts come to us a certain kind of way, it is important for us to think about the implications that our rulings will have on the facts that are being presented to us. And when we make our rulings and when we demonstrate our rulings, we need to make sure that they're narrowly tailored so as not to, lean so far one way to give one group of influence or lean another way that totally takes away the capacity for one group not to be able to get the voice and advocacy that they need. Because at the end of the day, lives are being lost when we are not being attentive to the commitment that we have to the rule of law, but also to the lives that are impacted when we don't do our jobs as consistently and importantly as we need to. So thank you.
Thank you, Judge Protasiewicz.
That's a very challenging question. I have not carefully read the dissent. I have not carefully read the majority opinion. I don't know what the legislative history is behind the law in the District of Columbia. I didn't hear the attorney's arguments. I haven't reviewed the briefs. So I'm not able to tell you, do I agree with the majority or the dissent in that case? I can't tell you. What I can tell you is it's all a balancing act. Obviously, we have the Second Amendment. People are entitled to bear firearms. We all know that. I also can tell you that I know lots of responsible firearm owners, many responsible firearm owners. I also have seen many irresponsible firearm users. So the question becomes, was that an overreach by the United States Supreme Court, or was it an appropriate decision? On this particular case, I'll tell you, I am well aware of what's going on in the community with firearms. I am well aware that the people in the community frequently don't feel like they're safe because of the number of firearms in the community. But like I said earlier, I can also tell you there are many, many responsible firearms owners and firearms users. So I'm not going to take a position on this case until I very carefully read it. Thank you.
Thank you. We're getting close to time, but we have 2 quick audience questions. The first one, I'm hoping you do it like in 3 sentences or less, all right? Favorite founding father and why? Justice Kelly, you were up first.
I guess I'd have to say Alexander Hamilton.
Oh, come on, man. Everybody gonna say Alexander Hamilton, man. You done seen the musical, man. You done seen the musical, y'all.
So here's the thing. So I can't rap, but he's still my favorite. And I think the reason for that is because he wrote so extensively about the nature of the court and its function. He really was the first expositor of the important but limited role that the court has in a constitutional scheme of government. He understood the dangers that happen when you combine the powers of different branches into one. He called the court the least dangerous branch. Why? because it has neither the power of the sword nor of the purse. It can't require anything. It can't do anything with motive force. That belongs to the executive branch. All it has is its judgment. And he goes on to say that even the execution of that judgment is entirely dependent on the executive branch. It is the least dangerous, but only so far as it does its job, and only its job. Because he went on to say that if it should ever combine itself with the powers of the legislature, that would then become the very definition of tyranny. What I've heard a fair amount this afternoon is my opponents talking about their values and what they think that the law ought to do. That is the step towards the combination of the power of the judiciary and the legislature. That is a step we cannot take. Alexander Hamilton is my favorite because he explained the importance of keeping those branches separate. And he went on to explain the dangers that occur if the court steps outside of its constitutionally limited role. So that's why he's, and great Broadway production. I'm sorry, that
just
was
about to
that was maybe 4 sentences?
A lot of
Four run-on sentences.
Yes, indeed they were.
Judge Mitchell.
Well, to go off what he said, Alexander Hamilton, I'm not going to take away my shot. All right? I think for me, if I have to give an answer, which is always complex, for African American whose communities were enslaved during the time of the founding of this country, I would say Thomas Jefferson probably gives me the greatest one because he also penned those revolutionary words of life, liberty, and the pursuit of happiness. But he was also the one who also codified the idea of what race is in the Notes of State of Virginia when he said that that blacks are inferior and whites are superior, giving our country the first time a theory of race in our country. So it is the juxtaposition of founding fathers who also aspired for what this country, this young country, to become, but it's also recognition that as they had the aspiration for some, they didn't have that aspiration for others. And so I live in that intricate space of balance between those two communities at the same time, because there were so many who were not included in that space, and yet at the same time, it is just, those are the same values, again, that my mentor and God mentor Justice Marshall said that we have a right to live in as well. And they use that same argument to say we should overturn these laws that oppress people and make sure that we have integration in our community. So you stole Alexander Hamilton, so I had to go to Thomas Jefferson.
Judge Protasiewicz, please.
Our founding fathers were obviously a brilliant group, but they had some flaws, right? I like the 2 founding fathers that my opponents have mentioned. So since we'll go with somebody else, I'll take John Adams. Brilliant, creative, hardworking, hard, scrappy New Englander, staying away from Abigail, fighting so hard to form this country. So I'll go with John Adams.
Thank you. Judge Doral.
I'm going to take a little bit different approach to this, and I think back to our very first president, George Washington. And the reason why I'm selecting him is because he had an unwavering commitment to his faith in the face of incredible tyranny. A man who, kind of like a David against Goliath, went out and led our troops in battle against the tyrannical government that King George had thrust upon the colonies. And even though there weren't a lot of founding mothers, I know there were a lot of women supporting those men, women like Betsy Ross, of course, but I can still look at someone like George Washington and be very proud of his faith and how he brought that faith to his role as president. And I'm proud to say I like him a lot.
All right, last question for all candidates. The state's high court has and is expected to hear many cases addressing voting laws. Judge Mitchell, we'll start with you. How do you plan to protect voting rights?
As I've always talked about, for me, voting is an essential part of my of my values because it is rooted in the law. In 1965, when they signed the Voting Rights Act, the whole intention of the Voting Rights Act was that all branches of government, including civil rights leaders who endured the brutality of Selma, was to expand access for all people to participate in the political process at the local, state, and national level. Anytime we have an erosion of that law and those principles, we're losing what is foundation for our community. So I say for me, obviously, I don't know facts. I don't know what cases may be brought. I don't know any of those issues, but I can tell you that being able to overcome so much in the historical nature of our community so we could be able to check that box is in my DNA. And so it is a consistent value that I want to make sure that we protect that value, and we make sure that within our discretion to be able to view the law a certain way, that the lenses that we have are rooted in making sure that we protect that. I don't wear glasses, but I have a bifocal-like lens when it comes to the Constitution. I believe we have to have a sense where we pay attention to the historical nature of the document, but we also have to have a living approach to it to understand the implications of where the law moves us to. And so for me, there's nothing more critical than the voice of the democracy of people and making sure that they have access to the ballot and making sure they have access to the right to vote. And that goes from no matter how young you are, how old you are, everybody should make sure that they have access to that. And when we can make those decisions, and we do, I think we must lean always on the side of opening our democracy rather than shrinking it.
Thank you. Judge Bertazewitz?
Thank you. I think this question dovetails into some of the areas that we've already talked about, right? Our founding fathers, maps, gerrymandering. And I suspect the reason we are asked about our favorite patriot or founding father has to do with what our values are, what our history has taught us, what we think going forward. Remember, we fought that battle against Great Britain in the 1700s when it wasn't necessarily popular. A third of the people wanted to split from Great Britain, a third of the people wanted to stay with Great Britain, and about a third of the people were indifferent, right? But that third who were really, really fighting to separate, were fighting to separate for one reason. They wanted fair representation. Remember the Boston Tea Party? Remember the Stamp Act, everything we've talked about? Taxation without representation, it all comes back to that. And then that question dovetails with that gerrymandering question. When I said to all of you, do the voters pick the politicians or do the politicians pick the voters, right? It all comes back to representation, and every single person's voice should be heard. That is what is so critically unique about this country. Every single person's voice should be heard. So will cases be coming to the Wisconsin Supreme Court? I would suspect so. But I can tell you our entire history is all about our democracy and having everybody's voice heard. Thank you.
Judge Durrell?
So not only is the right to vote essential, it is core to our democracy. I also believe that election integrity is vital. The system needs to be fair and reliable, and the people need to be confident that it works as it should. In future cases making ballot access claims, I will apply well-developed case law from the United States Supreme Court. And as with any case that comes before the court, I will listen to the challenge and then apply the law fairly and faithfully to the facts of that case. Thank you.
Thank you. Justice Kelly?
So I believe part of the question was, how will you enforce the law? Could you read that part again?
How do you plan to protect voting rights?
All right. So my plan to protect voting rights is to do my part of the job. So this goes back to the whole question about what is the proper role and function of the court within a constitutional construct. Now, I know we're sitting here talking about a Supreme Court election, and so we're focused pretty heavily on the court side of it. But a justice must never lose sight of the fact that the justice resides in only 1/3 of the government created by our Constitution. And the protection of voting rights is a collaborative work amongst the three branches. The legislature makes the law, the executive executes the law, And the court does one thing. It resolves legal questions about the law. It doesn't tell the legislature you didn't think wisely about this. It doesn't tell the legislature there's a better way of doing this. It doesn't tell the executive you should be more energetic. A proper justice concentrates on simply the role of the court to decide disputed questions of law and use that to resolve the case, and nothing more. Now, some might have more ambitions for the role. Some may look at voting rights and say, we need to be more active in this. We need to reach outside the authority of the courts. We need to adopt laws that I think should be in place. Or perhaps we'll just stretch the boundaries creatively of the laws that are already there. And that's not for us to do. That would break faith not only with our Constitution, it would break faith with we the people of Wisconsin, because it would be going beyond what you have asked us to do. And we'd be venturing into that space that Alexander Hamilton warned about, where tyranny resides, when we start combining our power with the power of the other branches. How will I protect? First and foremost, by not exercising anything but judicial authority. And then by faithfully applying the terms of the law that your representatives and legislature have chosen. And then relying on the people of Wisconsin that if they think that there needs to be a different standard, that you'll take care of business. You'll let your legislators know that there needs to be a different standard. Thank you.
Thank you. Thank you to all four of you for coming today. Thank you to our sponsors, Weldon State Bar. Thank you all for coming. Listen, we appreciate the time. On behalf of Emily and myself, thank you very much. Have a wonderful day.
News 3 Now is always on.
Get the Channel 3000 app, activate the push alerts, and we will send you breaking news, traffic, and weather alerts as it happens.
The Channel 3000 app. Get it now.
Powered by News 3 Now.